and welcome to Arbitration Acumen, a podcast from Bracewell's International Arbitration Group that connects in-house counsel and arbitration practitioners with industry experts, institutional insiders, and top arbitrators from around the globe to share their views on key issues in arbitration today. You can reach out to any of today's speakers by emailing arbitrationacumen@bracewell.com. And we hope you enjoy this episode of Arbitration Acumen.
Welcome back to the next episode of Arbitration Acumen, in which we'll discuss the Abu Dhabi International Arbitration Center, otherwise known as ArbitrateAD, with Maria Mazzawi, who is ArbitrateAD's registrar. I'm JP Duffy. I'm an international arbitration partner at Bracewell, based in New York, that acts as both counsel and arbitrator in international arbitration seated around the world under a variety of governing laws and arbitral rules. I'm qualified in New York, England, and Wales, and the DIFC courts in Dubai, where I previously practiced. With me today is Maria Mazzawi. Maria is a highly regarded international dispute resolution specialist who's been based in the Middle East for the past 14 years. Maria is a trilingual civil law qualified practitioner and is widely recognized as one of the region's leading arbitration professionals. She was featured in both the 2022 and 2023 Legal 500 Middle East Arbitration Power List. She's a fellow of the Chartered Institute of Arbitrators, and she also currently serves as co-vice chair of the CIA ARB's UAE National Committee. Before assuming her role as the registrar of ArbitrateAD, Maria built a distinguished career across the arbitration landscape, including more than a decade in private practice with international law firms and experience sitting as an arbitrator. She's a well-known voice in the arbitration community, regularly speaking at leading regional and global conferences and contributing to prominent industry publications. As you can tell, we have a great guest today that can offer a wealth of knowledge about ArbitrateAD and its current initiatives. But before we hear from Maria, I want to give some very short background information about ArbitrateAD for those audience members around the world that might be less familiar with it. ArbitrateAD came into existence on February 1st, 2024, following a restructuring and renaming of the Abu Dhabi Commercial and Conciliation Center, which had been established by the Abu Dhabi Chamber of Commerce and Industry in 1993. ArbitrateAD seeks to be a premier international arbitration institution that furthers both Abu Dhabi and the UAE generally as a hub for international arbitration. And ArbitrateAD itself has received major institutional recognition recently. It was awarded the 2025 GAR Guide to Regional Arbitration Award for arbitral institution that impressed, for having made great strides, including the formation of an impressive arbitration court and its appointment of a new registrar and chairperson. Since receiving that accolade, the momentum has continued, as just last week, ArbitrateAD was nominated for another GAR award, this time for the 2026 Campaign for Greener Arbitration Award for Sustainable Behavior. ArbitrateAD itself has a three-tiered structure that's comprised of a board of directors, an arbitration court, and the secretariat, within which sits the case management office. And the case management office is the body responsible for the day-to-day administration of cases within ArbitrateAD. ArbitrateAD's board, which is comprised of eminent arbitration and business professionals located within and without the region, provides strategic direction to the organization. Its court of arbitration oversees arbitrations the center is administering and is comprised of prominent international practitioners from 11 jurisdictions, all of whom have experience in the region. The case management office, which Maria heads as registrar, manages the center's day-to-day operations as well as interactions with parties and arbitrators on individual matters. ArbitrateAD has administered almost 105 matters between February 2024 and January 2026, so it's off to a very good start. And within its second year of operation, the center also launched the Arabic version of its arbitration rules, new mediation rules, and new adjudicator appointment rules, widening its service offering to parties. So as you can see, there's been a lot going on at ArbitrateAD, and with that background, let's turn to Maria to hear directly from her. Welcome, Maria. We're thrilled to have you with us today.
Thank you, JP. It's a pleasure to be here with you and the Arbitration Acumen audience today.
Great. Well, let's start with just some basic statistics about ArbitrateAD, just to kind of give the audience a sense of what's going on there. How many cases did ArbitrateAD administer in 2025?
We've seen a really strong trajectory at ArbitrateAD with a 38% growth rate in caseload from our first year of operation to our second, We've actually just launched our inaugural biennial report, which is available on our website, and I'd encourage anyone who wants to explore the full picture to take a look. In terms of numbers, for 2025, ArbitrateAD administered 61 matters, compared with 44 matters in 2024. So to break that down a bit further, in 2025, we administered 44 arbitrations, 3 appointing authority cases, and 14 Abu Dhabi Judicial Department requests for nominating arbitrators, compared to in 2024, where we administered 32 arbitration requests, 1 appointing authority request, 1 conciliation request, and 10 requests from the Abu Dhabi Judicial Department. So the growth is not only clear in the headline numbers, but also across the different types of matters that we handled.
Fantastic. That's always a very, very, very good sign in my view that there's a lot of buy-in in the region and also confidence in the organization. Now, how many of those cases were international?
I'd say about 18 to 20% of them are international.
Wow, that's really good to hear as well. What industries did those international cases come from?
It's quite a diverse mix, actually. Looking at the industries across all of our caseload, it tracks closely with the economic profile of the region. Construction is by far our largest sector at around 50% of the caseload, and real estate adds another roughly 18% on top of that. So between these two, we're just at over 2/3 of everything we administer. Beyond construction and real estate, commercial disputes make up the next largest slice. And we also see a steady stream of professional services and insurance matters, and then a smaller but meaningful tail across energy, oil and gas, and intellectual property. So while the headline is very much construction and real estate, the remaining third is genuinely varied. And that diversification has been growing year on year as the center's profile expands internationally.
Got it. Well, as you say, that would certainly match the economic profile of the region. Maria, what countries were the top 5 users in 2025 within the international component of cases?
In terms of top users in 2025 within the international component of our caseload, the United States actually comes on top. And then we see a cluster of jurisdictions in roughly equal proportions, and that includes Germany, Lebanon, Saudi Arabia, and India. It's a mix that really reflects both the trade and investment ties that flow through Abu Dhabi and the increasingly international character of disputes coming to the center.
Okay, so Germany is within the top 5 as well.
Yes.
Because that would certainly make sense to me, given the economic profile of the region, that India would be one of the top users. Interesting to hear that the U.S. is the top, I guess, the top international user. Is that correct?
Yes, that's correct.
Excellent. And what general percentage of cases are conducted in English each year?
It's about an 80-20 mix. To be exact, 84 of our cases are in English and 16% of them are in Arabic.
Interesting. And are there specific market segments that ArbitrateAD is targeting for international cases?
The short answer is that all industries are welcome. We're an open-door institution and we administer disputes across the full industry spectrum. That said, there are a few segments where we see strong regional demand and where the center is particularly well positioned internationally. The first is family businesses disputes. Family-owned enterprises are central to the Middle Eastern economy, and many operate internationally, and they often need a framework that is confidential, efficient, and sensitive to generational dynamics. Our recent Memorandum of Understanding with the Abu Dhabi Family Business Council supports exactly that, both regionally and as part of our international offering. The second is construction and real estate, which is a natural market. It already forms the largest share of our caseload, and with the scale of major projects across Abu Dhabi, the UAE, and the wider region, this will naturally involve many international parties, and that segment will only continue to grow. And I'd say the third relates to the broader services ecosystem tied to Abu Dhabi's economic strategy. Our Memorandum of Understanding with the Abu Dhabi Projects and Infrastructure Center, ADPIC, is a great example. ADPIC oversees the Emirates' multi-billion capital projects program, and under that collaboration, ArbitrateAD acts as the appointing authority for adjudicators and dispute avoidance and adjudication boards under ADPIC's standard contracts, and we are also the designated arbitral institution for disputes arising under them. And this embeds the center into the Emirates Infrastructure Delivery Framework, and it naturally brings a strong international element given the inherently cross-border nature of the sector and the scale of the international parties engaged in these projects.
Interesting. Let's shift gears then and talk a little bit about the ArbitrateAD rules, because those came into effect on February 1, 2024, when the organization relaunched, and they apply to any arbitration commenced after that date, including where the parties agreed to refer their disputes to the ADCCAC, correct?
Yes, that's correct. The rules came into force on the 1st of February 2024, and they apply to any arbitration commenced on or after that date. They also catch legacy clauses, so disputes referred to the Abu Dhabi Chamber or to ADCAC are subject to ArbitrateAD rules of arbitration, where these are filed after the 1st of February 2024. The one caveat, though, is that for ADCAC clauses, the emergency arbitrator provisions and the expedited proceedings provisions do not apply unless the parties, of course, expressly opt in.
Okay, well, the ArbitrateAD rules, I was looking through them, are obviously quite modern and they reflect current international best practices. But what are some of the salient features of those rules?
Thank you. Yes, they really are. ArbitrateAD's rules are intentionally designed for modern and efficient case management in line with international best practice. My personal favorite feature of the rules actually is the court-level scrutiny of awards that we offer. For me, that's a really salient offering, but I know we'll come to that shortly, so let me walk you through some of the other highlights, perhaps in the order that they appear in the rules. So starting at the front, Articles 5 and 20 set the tone. Article 5, for instance, provides that, except as otherwise ordered by the tribunal, all written communications in the arbitration are to be exchanged digitally. So the default is electronic filing, electronic communications, and platform-based workflows. Sitting behind that is docketAD, which is our case management platform, a secure and digital environment for communication and file sharing between the parties, the arbitral tribunal, and ArbitrateAD. All of our institutional arbitration cases are administered through docketAD, and the purpose is to give the parties and tribunals a secure and efficient way of communicating and exchanging documents and submissions, and the platform also serves as a complete file of the case materials, archived for 1 year after the arbitration is terminated. Beyond that, the rules expressly support virtual hearings, electronic evidence, and end-to-end digital administrations. The rules make clear that the adoption of technology and end-to-end digital administration is the norm rather than the exception, and there are many more features that can be discussed.
What are some of the other features of the rules that you think are worth discussing?
There are many features in the rules that we can discuss. Court scrutiny, the expedited proceedings framework, emergency arbitration, early dismissal, and provisions for multi-party and multi-contract arbitrations. But let me walk you through a few of them in the order that they appear in our rules. So at Articles 10, 11, and 12, we deal with multi-party and multi-contract arbitration, as well as joinder and consolidation. Our rules expressly allow the court to join additional parties or consolidate related arbitrations where appropriate, always after giving the parties an opportunity to be heard, and by reference to jurisdictional and efficiency considerations. Article 10 also enables a single arbitration to cover multiple claims under multiple contracts, where the arbitration agreements are compatible and the dispute arises from the same transaction or the same series of transactions. It's a practical tool to avoid parallel proceedings and reduce cost and delay. And that's a running theme that we have throughout the rules. Another example is Article 22, which addresses the seat of the arbitration and obviously recognizes parties' agreement on seat. But in the absence of any such agreement, the default seat under our rules provides for the ADGM, and that's a feature that many international parties find attractive. Article 24 covers the terms of reference, and under our rules, they're optional rather than mandatory, and the tribunal may propose them on its own initiative or at a party's request. And if a party declines to sign, the rules provide a clear institutional fallback, which is that the Court of Arbitration can approve the terms of reference in the event of default, ensuring that the arbitration continues without delay. And as such, a refusal to sign cannot derail the process. On evidence, the rules are deliberately practical. Article 31.5 gives the tribunal discretion to determine the consequences of a party's failure to comply with time limits, whether that's adverse inference, exclusion of late materials, or cost implications. And Articles 31.3 and 31.4 expressly empower the tribunal to direct the parties to focus their submissions on issues that the tribunal considers relevant, but that may not have been fully addressed. So the tribunal is given broad and explicit powers on burden of proof and evidence management, and we have actually seen these articles invoked a number of times. Moving on to Article 41, which modernizes the form and delivery of awards in two important ways. First, it expressly permits electronic signatures where the governing law allows it, something that our arbitrators actually really appreciate, and it's a popular feature with our tribunals. And the second one is that once signed, awards are delivered digitally through the Centre's case management platform and treated as originals for all relevant purposes. That combination reduces administrative delay, lowers costs, and creates a secure timestamp record that supports enforcement and compliance. And finally, we have a suite of provisions reflecting international best practice, including early disclosure of third-party funding so that the case management office, tribunal, and parties can identify and manage any conflict or funding-related risks from the outset. Obviously, transparency being the guiding principle throughout. And those are some of the hallmarks of the ArbitrateAD rules as well.
Those are all great features and certainly modern ones. Let me just circle back to a point on Article 22 in the seat, because I think you mentioned that in the absence of a designation, ADGM becomes the seat. Is that correct?
Yes, that's correct.
Great. And the ADGM, as I understand it, you mentioned, I think, that it has its own common law legal system. That's based on English law, right?
Yes, that's right.
Okay, so that will certainly be a familiar legal structure to many, many practitioners, both within the GCC or the Gulf region, and certainly within the arbitration space as well, given the number of practitioners that have experience with English law. So that's always a great feature as well. Now, just a question on Article 24 in terms of reference. You mentioned that the tribunal has the power to order terms of reference or to direct the terms of reference be written up if it so chooses. What are some circumstances in which the tribunal might wish to do that?
A few circumstances, actually, but as mentioned, under Article 24 of our rules, terms of reference are optional rather than mandatory. The tribunal may propose them on its own initiative or at a party's request. In practice, they tend to be quite useful in a number of recurring situations. So, for example, in the case of a complex or multi-party arbitration where you've got several claimants, respondents, or claims under multiple contracts, terms of reference give everyone a shared map of who's claiming what against whom and on what basis. And another potential scenario is where the pleadings are still evolving or where the relief sought is unclear. Terms of reference can be a very useful tool to lock in the scope of the dispute early, identify the issues for determination, and avoid surprises later in the proceedings. And the third could be where the parties come from different legal traditions, as it can really help align expectations between counsel and the tribunal at the front end of the case. But again, this is entirely optional. And there are some institutional safeguards, which is, for example, the referral of the terms of reference to the court for approval, where there's a refusal to sign so that proceedings can move forward.
Now, you mentioned docketAD as well, I think, and you said that allows the parties to administer the case as well as the tribunal to communicate with the parties. And I assume that's a secure platform that's been pretty well thought through.
Yes, of course. docketAD is powered by HiQ, a world-leading supplier of secure digital solutions for the legal profession. It is ArbitrateAD's secure digital-first case management platform. So each of our administered arbitration cases gets a dedicated case site on Docket where the request, all submissions, exhibits, tribunal communications, and case management office correspondence are stored and preserved as an auditable record. The platform supports electronic filing, role-based access for parties, tribunal, and the case management office. and is fully timestamped with an audit trail accessible to the case management office. It is built on enterprise security standard with encryption, two-factor authentication, and regular testing, and it keeps files stored in UAE cloud facilities with backups to protect availability and confidentiality. So using docketAD lets us run tighter case management practices. And for tribunals and parties, that means faster exchanges, fewer administrative delays, clearer chains of custodies for document, and a much stronger record for enforcement. Service is also trackable because the case management office is able to see when a document is accessed.
Excellent. Now, one of the things that intrigued me as well, just because you mentioned the proportion of the caseload that's falls within the construction and real estate industry, was Article 34 and preliminary measures. Why don't you just talk about that a little bit too?
Of course, Article 34 is our provision on preliminary measures, and it's designed to be very practical, especially for sectors like construction and real estate where timing and project continuity really matter. It gives tribunals broad authority to order measures that preserve the status quo or protect evidence or prevent harm before the final award. So the idea is to give parties access to fast and effective relief within the arbitration itself, so they don't need to run to courts mid-project. It's one of the tools that helps keep disputes moving without disrupting ongoing works.
Yeah, and certainly I think in the sectors that you mentioned as the largest ones, things like injunctive relief or even interim specific performance or status quo relief can be very, very useful. Now, I noticed as well that Article 45 has an early dismissal or early disposition provision. That's always one that's near and dear to my heart. So why don't you talk about that a little bit?
Of course, Article 45 is our early dismissal provision, and it's really about keeping cases focused. It allows the tribunal to dismiss claims or defenses that are manifestly without legal merit or inadmissible or outside its jurisdiction. It's a fast, proportionate tool to clear out issues that don't warrant a full evidentiary process. The tribunal can act on its own initiative or upon an application by either party. And importantly, when an application is made, the rules require the tribunal to issue its order or award within 30 days of the filing. And that's, of course, after giving the parties an opportunity to be heard. So it's a tight, efficient timeline designed to save time and costs and keep the arbitration efficient and on track.
Interesting. So the tribunal, in addition to the parties applying to have claims or defenses struck for being manifestly without legal merit, the tribunal could, on its own volition, raise those issues.
Yes.
Wow, great. That's certainly a distinguishing feature. And early disposition has become such an important facet of arbitration at this point. I know certainly many rules are now expressly incorporating the process in their rules because it's certainly something that the community has demanded that's being well received.
Yes, of course. Article 35 is our emergency arbitration provision. It offers a fast and standalone route for urgent interim relief, which is particularly important in sectors like construction and real estate. Under that mechanism, parties can apply for an emergency arbitrator even before filing the full request for arbitration. The Centre aims to appoint the emergency arbitrator within 24 hours, and the emergency arbitrator must issue a decision within 10 days, with only limited extensions available through the case management office. The order remains in place only if the full request for arbitration is filed within 30 days, which ensures that the emergency process is used responsibly and tied to a substantive dispute. It's a very practical mechanism, and it's one that's widely relied on.
What's sort of the outside limit in most cases that you would expect to see extensions granted to?
I would say maybe a day or two. It depends on the reasons for the extension and the length of the extension sought, but given this is within the emergency mechanism, I really can't see it past that sort of very limited window.
Yeah, and that's certainly very quick. I mean, I sort of think of emergency arbitration being concluded within, usually I think most rules are about 14 or 15 days. So 10 is certainly consistent, but very quick. So that's very interesting. Are you aware of any emergency awards having been issued?
We actually haven't had any emergency arbitration requests yet, although I'm pretty sure I just jinxed it and one is on the way.
That's right. Well, they'll probably wait until Friday afternoon or right before the weekend, at least to contact you so they start your 24-hour clock on the late night appointment process, which is always funny.
Yes.
I seem to be a victim of getting those calls. I shouldn't say victim because I always appreciate them, but I get those late in the day on Friday sometimes like, we've got an emergency application. Are you available? And I'm sure I'm the 10th person that's been called that, is the first 9 were smart enough to say, no, I'm not available. But in any event, correct me if I'm wrong, but I think the track record thus far for the enforcement of emergency awards generally in the UAE has been relatively positive.
Yes, absolutely. The UAE is a very arbitration-friendly jurisdiction. We have a modern federal arbitration law that firmly supports the arbitration ecosystem and the enforcement of award, and equally a judiciary that has consistently taken a pro-arbitration, a pro-enforcement approach in line with that law. So that gives parties a high level of confidence of the arbitration ecosystem in the UAE.
Now, there's also an expedited proceedings provision under the rules, correct? Why don't you tell us a little bit about that? Yeah.
Yes, exactly. We do have an expedited proceedings framework, which is designed to be a fast, streamlined track for lower value disputes. The default threshold is 9 million dirhams unless the parties agree otherwise, and I believe that is about $2.45 million. Cases in the expedited track move with limited written submissions, a sole arbitrator, and a simplified process, including the option for summary reasonings. Crucially, the tribunal must issue its award within 4 months of receiving the file, with a possible extension of up to 2 months. And the court can always move a case out of the expedited track if the complexity or fairness of the matter requires a fuller process.
Got it. Would one of those circumstances as well be a party, say, for instance, a party asserting a new claim that materially increases the monetary value?
Yes, exactly. That would be one of the circumstances. If a party introduces a claim that materially increases the amount in dispute, the court can decide that the case no longer fits the expedited track. The whole point is to keep the process fair and proportionate. So if the value or complexity shifts in a very meaningful way, it can be moved back to the standard procedure.
Interesting. Okay, because I know certain rules where they say, and I've had this experience as both counsel and arbitrator, where they say it's a pure monetary threshold issue. For the most part, oftentimes a party asserts a counterclaim or something like that. It reflexively kicks it out of the expedited rules, and there are certainly times when that's not really necessary. So good to hear that there's some rationality there.
Yes, most of our expedited cases have stayed comfortably within the 4 months timeline. We had one where the tribunal requested the additional 2 months extension, bringing it to the full 6 months, but all of them have remained within the expedited track, and none have needed to move out of the EP process.
Interesting. And can parties opt into the expedited rules even if they don't necessarily meet the initial thresholds?
Yes, of course, absolutely. Parties can opt into the expedited arbitration framework, even if they don't necessarily meet the quantum threshold under the rules.
Excellent. Now, let's talk then just a bit about awards and award scrutiny. There's a presumption under the rules that awards will be issued within 9 months of the initial CMC, correct?
Yes, that's correct. The default time limit for the issuance of the final award under our rules is 9 months from the initial case management conference. The Court of Arbitration may, of course, extend that where needed, either upon a reasoned request by the tribunal or the parties' agreement. The Court of Arbitration can also extend the deadline on its own initiative if that's determined necessary.
Interesting. Okay. What sort of extensions, or let me ask it a different way, have you seen requests for extensions so far?
Yes, we've seen a handful of extension requests. Most of them have been quite short, usually 2 to 3 months, and for entirely understandable reasons, like the parties needing to move a hearing date. So yes, we've had a few, but all modest and all grounded in practical case needs.
Right. I was going to say, even if a 3-month extension is granted, that still brings it to within a year of the CMC, which is relatively quick.
Yes.
Now, one of the interesting features I noticed is if there's a 3-person tribunal and no majority decision, the tribunal president shall make the award alone. Did I understand that correctly?
Yes, that's right. Article 39 of the rules provides that Any award shall be made by a majority decision, but in the absence of a majority decision, the president of the tribunal can make the award alone unless the parties agree otherwise.
Now, I just didn't understand how that circumstance could arise. What does that actually mean?
So far, we've never seen that invoked, and I'm hoping that we perhaps don't see it in the near future. So, which is a good sign that there's the tribunal consensus of, majority on most of our cases. So, yeah, that's a good sign.
Okay. Well, good. Well, it's at least a good fail-safe provision to have.
Yes, it is a good fail-safe to have, but one that's that I've actually never seen exercised, even in my time in private practice in the UAE.
Now, what kind of scrutiny does the court provide to awards?
A scrutiny of awards is a feature of the ArbitrateAD rules that we take a lot of pride in. It's a court-level review, and the process is deliberately rigorous while still respecting that the tribunal alone decides the substance of the case. So scrutiny happens in 2 stages. The case management office conducts an initial review, which is then elevated to the Court of Arbitration. The court undertakes a much more detailed, rigorous check to identify any issues that could affect clarity, consistency, and ultimately enforceability. It's a thorough court-level quality assurance and one of the features that gives users real confidence in the award issued under our rules.
And that's a non-merits review, right?
Yes, absolutely. It's a non-merits review.
Excellent. Understood. So it sounds like it's akin to the ICC process for those that are familiar with that.
Yes.
And how long does the scrutiny process typically take?
It's quite a tight timeline. Under the rules, tribunals must submit their draft award for scrutiny no later than 20 days before the final award deadline. That means the centre has roughly 10 days for the full process between the case management office's initial review and then the court's more detailed check before sending back the comments to the tribunal. It's a compressed window, but it's one we've consistently met, and it's a timeline we're very proud of because it keeps the process disciplined without compromising quality.
Interesting. Well, it sounds like the court members then have a very on-demand schedule for awards.
Yes, they do. We have incredible court members, and we're absolutely grateful to have them.
Oh, that's great. Now, you mentioned as well earlier that awards can be electronically signed if permitted by the applicable law.
Yes.
I think that's now permissible under the UAE arbitration law, correct?
It is, yes, much to the relief of the arbitrator community.
Interesting. Okay, well, in the interest of time, I did want to touch just briefly as well on new service offerings. Let's just talk quickly about that, if you would.
Yes, absolutely. The Centre has recently launched 2 new sets of rules that are available on our website, our adjudicator appointment rules and our mediation rules. They're digital first, fast, and fully integrated into our existing case management infrastructure, giving parties more flexibility in how they manage and resolve their commercial disputes, and widen the Centre's offering to include dispute avoidance as well as dispute resolution.
Wow. Well, Maria, I think we could probably continue speaking all day about all the incredible accomplishments that ArbitrateAD has achieved in the last, really 2 years. But I think what I'd rather do is have you come back again in the future and give us updates on where things stand, because I think if things are continuing at the trajectory they are, there will be an awful lot to discuss.
Thank you very much. I look forward to being back. Thank you very much for having me. And we're very excited for what's ahead for ArbitrateAD.
Yeah, it's going gangbusters. So that's great. With that, I think we'll conclude our discussion for today of ArbitrateAD. I want to thank our guest, Maria Mazzawi, for her invaluable insights. And I want to thank you, the audience, for listening. You should feel free to reach out to Bracewell about today's podcast with any questions you might have, as well as to Maria, who's been a really incredible guest. And we look forward to having you tune in for future episodes in our Arbitration Acumen series. So let me just say another personal thanks to Maria. Wonderful to have you today. And we do look forward to having you back in the future.
Thank you very much for having me. Thank you, JP.
Thank you for listening to this episode of Arbitration Acumen. We hope you found it insightful and informative, and we encourage you to share it with your colleagues if you did. You can reach out to any of our speakers by contacting them directly or by emailing arbitrationacumen@bracewell.com. We welcome any questions or suggestions you might have for future episodes. And please subscribe to our podcast channel to stay up to date with our latest content.